Hi, I'm Jesse Bifulco, host of the LifeCounsel Podcast. Today, we'll discuss the types of conditions you can attach to a gift in your will. For instance, is it possible to give your wife a gift that depends on her not remarrying? Today, we'll answer the question about remarriage protection. And also, can you make a gift to your kids conditioned upon them raising their children in your religion or your grandchildren? As an estate planning lawyer, over the years, I've saved my clients a lot of money, but the value in money does not account for the invaluable benefit to those families of avoiding family conflicts because they had a great estate plan. But most people will never save that money or avoid those conflicts because they think estate planning is too complicated or they don't see a value. Or as we'll learn in this episode, they make conditions that are not legally enforceable, what you might call controlling from the grave. You don't want to find out you made a mistake by walking blindly into an estate planning pitfall that burns up your family wealth and magnifies the cracks in already fragile family relationships. At the LifeCounsel Podcast, we share useful information by telling stories. We try to make it entertaining, but these stories are not fairy tales. They're based on my 25 years of practice, and they're not just for families looking to learn about what makes a good estate plan. They're also for other lawyers. We want to give lawyers new tools to communicate what they do best, helping families. Our mission at LifeCounsel is to preserve family wealth and prevent needless family conflict, and maybe share a laugh or two along the way. Today I'm going to talk about some strange will provisions from actual wills of actual famous people. I'm going to talk about some conditions you might consider putting in your own estate plan. We'll also cover the topic of remarriage protection. That is, if you die, how do you keep your spouse from disinheriting your children? Okay, let's get started. Thinking about conditional gifts is to think about mortality and how we might use a gift at death to make one outcome more likely than another. Something that made me think about mortality early on was something my Latin teacher said to the class in high school. I went to St. Peter's Boys High School for the first 2 years of high school. Many of the teachers there were monks. They were called the Brothers of the Christian Schools. They had normal names like Brother Dominic, but of course, in an all-boys school, you can imagine that we made up less than complimentary names for these good and devoted teachers. Names like Brother Dirt and Brother Popeye, well, you get the idea. Brother Popeye taught Latin. It was said that if he caught you doing something wrong, he'd throw a piece of chalk at you. Well, flying chalk sounded like a pretty good diversion from Latin class. So on the first day of class, to test him, one of the students hit him with balled-up paper. The anticipation was palpable as the freshman class waited for Brother Popeye's reaction. But to our surprise, he didn't throw chalk. Instead, he began to tell us about something I now know to be called survivorship bias. Survivorship bias says that individuals who have already lived to an older age must have passed through many risks that could have caused their death, but they survived. This means they have a higher probability of continuing to live longer compared to the general population. The fun thing about the theory is that it creates the theoretical fiction that the longer you live, the longer you should be expected to live. The idea is simple. People who get older have survived more risks. They're often stronger and healthier. This means older people can sometimes live longer than you might expect. Their life expectancy actually gets better with age. For example, if somebody reaches 65, they will probably live even longer than what was predicted at birth. So Brother Popeye explained this. He said, older folks have proved their longevity. That's what he said. They already made it through tough times, like being a freshman at St. Peter's Boys School. We freshmen wondered what this had to do with us. And when would Brother finally throw a piece of chalk at Johnny? Then he finally got to the point. He said that young people like us students were statistically more likely to die before old people like him. In response to our obvious confusion, he continued, "It's true, because old people have proved their longevity, But the young people, on the other hand, have not proved themselves and are statistically more likely to die before the end of the semester. Well, we winced because at that we expected Brother Popeye to throw chalk at somebody. But again, no chalk. Instead, Brother picked up the paper that was balled up on the floor and he said, "I see someone has thrown a projectile." Our English word projectile comes from the Latin word projectus. Projectus is the past participle of procerere, meaning to throw forward. And then, with the speed and aim of an ancient Greek hero, Brother Popeye nailed Johnny right in the head with an eraser. Much better than chalk because it left a lined white rectangle on the side of his head and a cloud of dust. Speaking of mortality, I'm going to go over some conditions you might put into your will or your trust, and if those conditions are legal. If you listen to the end, you'll learn a common legal way to prevent your surviving spouse from disinheriting your children, and at the same time, reduce estate and gift taxes. When making an estate plan, you'll often hear me say that you should start with the end in mind. I call that your goal. Well, keeping the end in mind can mean different things to different people. Maybe it's about the goal in your estate plan, or maybe it's about what instructions you're going to put into your last will. What kinds of conditions can you put on a gift? What if you're concerned about the girl your son is dating or the boy your daughter is dating? If I die today, my daughter will inherit a bunch of money, and I don't want that jerk to get any of it. It's not unusual for parents to say to me something like this: "My son and his wife are going to get divorced. They just don't know it yet." Well, what if you die and you leave everything to your son, and after he's put that money in a joint bank account with your daughter-in-law, she files for divorce? Does she get half your estate? Can you condition the gift to your son on his wife not getting anything? What if you're concerned that your husband or your wife will remarry after you die and disinherit your children? Can you take away a gift to your spouse if he or she remarries? What if your faith is really important to you? 1,000 years ago, one of your ancestors walked away from paganism and human sacrifice and converted to the light of Christianity, or you belong to the ancient Jewish faith. Can you require your beneficiary to adhere to your family's religion? Today, we're going to look at some real-life examples that you might make or you might want to make and, rethink your plans. Okay, so if you do put something like that in your last will, is that going to be public? Recently, it was in the news, a famously cantankerous heir of the LL Bean fortune, Linda Bean, died. Her lawyers asked the probate court to seal her last will so the public could not read it. I don't know what they were trying to hide, but the judge rightly said no. You can read Linda Bean's last will right online if you'd like, despite her lawyer's wishes. Last wills are public documents, so if you want to say something strange or reveal a secret or have some embarrassing condition after you die, know this: the whole world will be able to read your will. The lesson there is that if you do put something private in a last will, it's not going to stay that way. First up, let's talk about conditions in wills. Is it legal to condition a will, condition a gift in a will, or trust upon your child marrying or not marrying someone? For instance, I give my son Paul a gift of $500,000, but on the condition he does not marry his girlfriend, Joanne. A condition that deters marriage or encourages divorce is typically not enforceable because it goes against public policy. However, some conditions about marriage or non-marriage can be enforced. For example, a Florida trust had a clause that disinherited, quote, any beneficiary who married outside the Jewish faith, unquote. The court upheld this condition because it applied at the time of the testator's death and did not encourage divorce. So, if the clause said, I give my son John $500,000, but only if he divorces his Gentile wife Sandra, that would not be enforceable because John was married to Sandra before the will was made, and that would encourage divorce. What about stepkids and his daughter-in-law? In New York, in a New York case, the father left money for the benefit of his son. The father left money for the benefit of his son, but not his son's wife or her children. But if the son remarried and had children of his own with a new wife, they would be beneficiaries of the gift. A not so subtle hint that mom and dad didn't like the daughter-in-law or the stepkids. In that case, New York said the conditions were legal and did not induce divorce. In a Pennsylvania case, a testator conditioned a $2,000 gift to each of his married children on marrying someone, quote, of true Greek blood and descent and of Orthodox religion, unquote. The court invalidated these conditions because they encouraged divorce, because the kids were already married, and encouraging divorce violates public policy. The New York and Pennsylvania examples sound like the same thing, but one was enforced and the other was not. The lesson here is to be very careful about how you draft such a condition, but understand it might not be enforceable. Also, you have a much greater chance of having your intentions carried out if you use an experienced estate planning lawyer. What about your spouse? Let's talk about something I call remarriage protection. How many times have you heard a story about a widowed mom or dad remarrying well beyond childbearing years, and then when they die, their adult children get nothing, and the step-parent gets the entire estate? And adding insult to injury, after the step-parent dies, they leave the estate to their children and none to the children of the deceased spouse. Go on X or Facebook or talk to your friends, basically, and you'll find heart-wrenching stories about families who have experienced this exact scenario. Heck, you probably know somebody. Google the story of J. Seward Johnson or Tony Curtis or Jerry Lewis. You'll see disinherited children, stepmothers getting sued, and accusations of bitter court battles and public last wills. If you read the LifeCounsel Scam Friday posts on scams and fraud, you know that there's scientific evidence of our brain changing as we age. We get less skeptical, we miss details, we get isolated, and this adds up to sometimes trusting, maybe even marrying the wrong person. While not every second marriage is some kind of gold-digging scheme, unfortunately, sometimes they are. Speaking of disinherited children, over the course of my 25 years of practice, I've definitely noticed this pattern sometimes emerge. A child may live at a physical remove from her or his elderly parent, and whether it's justified or not, the lack of personal interaction with the child, coupled with constant exposure to the new people in their lives, can result in that child being disinherited. Now let's talk about gifts to surviving spouses and remarriage protection. Is it legal to provide a gift to a surviving spouse, but only until they remarry? You might be surprised to learn that the answer is yes. This is a common way to prevent the disinheritance of your children if you die before your spouse. Well, you might ask, if I give my wife money, how can I take it back if she marries someone else after I die? I'll explain the technique to fix this problem at the end of this episode. So listen to the end to get the answer about what we call remarriage protection, and also a tip on how to use that same technique to avoid estate taxes. Here's a tricky one. What happens if it's not possible to tell who died first? If a gift is made and both the gift giver and recipient die at the same time, where does the gift go? It's relevant because sometimes who dies first dictates who the remainder beneficiaries will be. Because if A leaves everything to B and B leaves everything to C, but if B dies first, she leaves everything to A and A leaves everything to D and not C, then if A dies first, then C inherits. If B dies first, then D inherits, right? So it makes a difference who dies first. All 50 states in the District of Columbia have laws dealing with simultaneous deaths to address this issue. That means there's a formula or rule that will decide who died last. But remember, you may not like the result, so you should decide within your estate plan instead of leaving it up to a statute. This would be relevant if the husband and wife had different remainder beneficiaries. Perhaps each leaves their estate to each other, but then to their children and not to the other spouse's children. If the two people who died both had different beneficiaries in their plans, it makes a huge difference who dies first. What about a clause that says, if you contest this will, you get nothing? Whether or not that clause is enforceable is different in different states. Brother Popeye would use the good Latin phrase for this kind of clause and call it an in terrorem clause. I can hear his voice as he might have explained it. In terrorem means for the purpose of causing terror or fear, as in, I struck Johnny with a projectile in terrorem, or to make Johnny fear retribution for misbehaving. In the estate planning meaning, in the estate planning meaning, it is meant to cause the beneficiary to fear contesting the will. That's the in terrorem clause. Sometimes they call it a no contest clause. Those would be people who didn't take Brother Popeye's class. In Florida, no contest clauses are unenforceable. Many other states have adopted something called the Uniform Probate Code. In those jurisdictions, if the contestant shows probable cause of fraud or abuse, then they can still contest the will. And if their case fails, they will not forfeit any benefit they got in the will. They just had to have probable cause to avoid losing the gift after a contest. Several states have adopted this provision, including Alaska, Arizona, and Colorado, among others. Some states permit a will contest or a trust contest, but it has to be upon certain grounds, like fraud or undue influence. The effect of this law is to allow lawsuits and ignore the penalty clause. Why? Because fraud and undue influence are the most common claims. But what do you do if it is one of your estate plan goals to disinherit a family member, and you just know that person's going to contest your will when you die, and you want to prevent that? If you're in one of the many states that prevent the penalty clause, you're going to have to come up with a better solution. An experienced estate planning attorney can offer solutions to that problem. Now let's talk about some famous examples of unusual conditions in wills or trusts. Remember Leona Helmsley, who owned the Empire State Building? In her will, she left $10 million to her dog Trouble, a Maltese. This is too ripe for bad jokes to resist, so dad joke alert, incoming dad jokes. I heard they used to give Trouble a couple $1,000 a day for walking around money. But Trouble got addicted to milk bones, so they had to stop giving him cash. Oh, the burden of wealth is rough. But seriously, a dog, not even a Maltese called Trouble, can balance a checkbook. So Trouble had an entire entourage of people who would lose their jobs if Trouble died. Imagine what some people might do to keep that gravy train running. Okay, settle down. How about Harry Houdini? Harry Houdini, according to Brother Popeye's theory of conditional life expectancy, since Harry Houdini survived death hundreds of times, statistically, he should still be alive today at 151 years old. I think Doge found out he was still getting Social Security checks. Houdini, the famous escape artist, could get out of anything. Straitjackets, locked boxes, but also, unfortunately, meetings with an estate planning attorney. Unlike many of the characters in my stories, at least Harry Houdini had a will. His plan was to come back in his will. He planned to come back from the dead. Harry gave his wife Bess a secret code, and he said to her, have seances, and if the medium gives you this code, then you'll know it's me talking from the grave. I'll use our secret code. Bess held seances every year for 10 years, and none of the mediums ever got the right code. I think, however, that the real story is that Harry really did come back, and that Beth just didn't want Harry telling her what to do from the grave. Harry wants you to know that you're spending too much money on fancy hats. Harry asks that you stop being so friendly with Chad the landscaper. You faker, that's not the code. Get out of my mansion, right? What about this condition? Can you condition a gift to encourage new life? Giving out money is if someone has a baby. There was a Canadian lawyer named Charles Vance Millar. Back in the 30s, when Millar died, his will said that he would leave his entire fortune to, quote, the woman who has the most kids in the 10 years after I die, unquote. The newspaper called it the Great Stork Derby, and many families took up the challenge. Newspapers had headlines like, "Who's winning the baby race?" So we started out talking about conditional gifts. We talked about religious conditions, divorce, and remarriage. And I mentioned that married couples with children sometimes want to protect their children from the possibility of disinheritance due to the remarriage of the surviving spouse. In this scenario, one spouse dies and leaves the entire estate to the survivor, that is, their widow, who then remarries and leaves the entire estate to a brand new wife or husband. What can be done to prevent this? Perhaps you're a younger couple or even retired empty nesters, and you both think that it's possible that if one of you died first, the survivor might remarry. Maybe you're okay with that, but half the estate or more belonged to you, and you want your children to inherit some of that. I was once in a meeting with a married couple. They had been married a long time. They started out with nothing and worked hard together to build a substantial estate. They had 2 children and several grandchildren. Ma and Pa were getting up there in age, but were still working hard as always. Maybe Pa had surgery or some kind of health scare, so they decided they should finally make an estate plan. During the estate plan interview, it's important to always raise the issue of remarriage protection with a married couple, but it can be awkward. The term remarriage protection is a convenient shorthand in office conversations with the paralegal, but it feels really crass when talking to actual people who dearly love each other and are devoted to one another and have the same children. But sometimes after gentle prompting fails, or maybe it's the end of a long day, you might just come right out and ask, "Do you folks want to discuss remarriage protection?" At that, Pa slammed his hand down on the table and exclaimed in a loud voice, "I want that." Well, when I looked at his wife, she just rolled her eyes. I could hear her thoughts. This old coot thinks I'm going to get married after he dies. One time was definitely enough. But no, that wasn't what Pa meant. He went on to explain, "I was thinking of me, not her. If my wife dies first, I don't want the casserole ladies coming around and sweet-talking me out of leaving our estate to our children." And that's the thing about remarriage protection, because it could be either spouse who dies first. It could be either one who has some limitations put on their use of the entire marital estate at the death of the first spouse. So they're usually all right with it. So you say, if my spouse remarries after I die, my surviving spouse loses the right to some part of the estate. But if you died and your spouse owns the entire estate, how do we take some of it back after he or she remarries? The answer is you don't give it in the first place. Instead, your share of the money goes into a trust. You give your share of the marital estate to a trust instead of to a person. Your surviving spouse may be the beneficiary of that trust during his or her life, but he or she does not own your share of the marital estate, your share of the money. It's a subtle difference, but a very important one. If the trust owns property, then the surviving spouse cannot change the remainder beneficiary. Let me repeat that. If the trust owns money, the spouse gets to use it, but she can't say where it goes next if there's anything left. It also gives the surviving spouse creditor protection as an added bonus. But we'll discuss asset protection in another episode. Okay, so in the beginning I said I'd reveal an estate planning technique that incorporates tax savings as well as remarriage protection. It's the tried and true AB trust plan. It's been around a while. It still works, but it's complicated, and you should talk to a knowledgeable, experienced estate planning attorney preferably one who focuses on larger value estates or gift taxable estates if the tax savings part is something you're interested in. But even if you don't need the tax savings, it's still great for remarriage protection. But here's an explanation of how the estate tax savings part works. Imagine you and your spouse each holding a glass of wine. Over the years, you've poured your efforts, savings, and love into these glasses, building a life together. And yes, it does get better with age. Anyway, now, picture what happens when you're both passed away. So you both have a glass and you filled it up with assets, right? If you simply pour one glass into the other, it might overflow. That overflow represents risk. Here's what could happen to the overflow. Estate taxes could be triggered if the total value exceeds the exemption limit. If you pour your glass into hers upon the first death, then it's subject to remarriage loss or elder vulnerability. This could lead to assets being redirected away from your children or grandchildren and to someone you never intended to receive it. But what if instead you preserve each glass separately? That's the idea behind an A-B trust plan. Upon the first death, one glass stays with the surviving spouse, the other is set aside in a trust, protected, preserved, and ultimately meant for your family. You put it in the cellar, let it age, and take it out when you need it. But ultimately, it's there for the next generation. This way, you avoid overflow. You use the first spouse's estate tax exemption immediately, protecting their share. And when the surviving spouse passes, their own exemption applies to their glass. 2 glasses, 2 protections. No spill, no surprises. Thanks for listening. And please like or subscribe if you enjoyed today's broadcast. Don't miss the next episode where I tackle a question I'm asked by more planners than you would think in my own practice. Can I have assisted suicide if I've lost my mind to Alzheimer's or dementia or am brain dead? Yikes. I'll answer that question, and I'll report on what's brewing in many state capitals around the country. I'm Jesse Bifulco, host of the LifeCounsel Podcast. Thanks for listening, and if you enjoyed my podcast or got something out of it, please press the like and subscribe buttons. Thank you.